Right, good afternoon everyone. Welcome to the Essex Branch AGM and legal update. I am Adam Hills, I'm the current Essex Branch Chair. The initial bits we need to do is very quickly just run through the AGM details before we move on to our main speaker, who is Rob Elvin today. There aren't any AGM minutes from last year. Due to the pandemic, I didn't host one. This year, the committee was elected via an online application, and today is just the brief outcome of that process. Sonia, can I just ask you to share the recent organogram that we've got, please? There are some changes to the committee. Most notably, we say goodbye to Brenda Weir. Brenda has been on the committee for around about 14 years. She was an executive member, she was an events coordinator, and more recently she has been a strategic advisor, so helping us make those decisions that we need to make. She sat on the research committee and has been able to secure a lot of contacts and speakers for us in the past. So those of you who remember the more technical speakers that we've had on nanotechnology, we have Brenda to thank for that. And today's speaker, Rob, is here because of Brenda's contacts. So many thanks for all the time that Brenda has given up volunteering for the branch and providing her thoughts and often well-informed and academic perspective and wisdom to us. We do have 4 new members joining us. We have Lorraine Larman, we have Isaac Onibodu, we have Louise Davies, and we have Sarah Walsh. So a big welcome to them, and I look forward to welcoming them all in our first committee meeting when we host that. 2 people to co-opt. We have Sonia, who will remain as our events coordinator, and then we'll be co-opting Sarah on, as she just missed out on the application process there. Future events wise coming up with the branch, hopefully many of you will have had a chance to listen to Michael's story last night, who died as a result of an electrical accident, and his sister Louise spoke to us. And that happened 16, 17 years ago now, and it's still sending out the ripple effects of what happens following a fatality, and the lessons that we can learn from that, because similar circumstances do still occur. There were 7 either side of Michael's death that happened in similar circumstances, and you know, I've investigated a number of other electrical incidents that were very similar as well. That was put on by in a collaboration with 2 other branches, and that was organised by the IOSH mentors team that we have here in the Essex branch. And their next event is going to be on the 1st of June. That is called Navigating Success, and that is part of the mentoring series. They're going to have 3 people, 3 ladies who have a very diverse background. They operate in offshore drilling, they are a business owner, and one of them works for TfL as well. And they're going to talk about their coping strategies when things have gone well, when things haven't gone well, give their reflections, what they've learned, what they've had to relearn, because you know, sometimes we do forget the lessons that we've learned in the past. And outline their aspirations for how you can do similar things and achieve as much as they've done. I'm going to ask somebody to, Sonia, if you've got it, just pop the link for that into the chat. So if you did want to register, then you can do that. If you aren't able to click on that link today, then if you go to Essex Branch's LinkedIn page, then that will also be available. And following Rob's presentation, we're just going to hear very briefly from Kieran and Lawrence, who are on the VP team for IOSH, just to give a central update what's going on with the grade reviews. You know, there's been a few changes with the blueprint and everything else, so they can just brief us on what that is about. So that's a very brief overview of the branch AGM. I'll just close that out there. And I do, Glyn, the previous chair, did manage to get across the medallion that I'm not going to wear, but I do have now. And we'll move on to Rob. So Rob is the managing partner for Squire Patton and Boggs in Manchester. He's been speaking to us for the past 5 or 6 years. Unfortunately, he wasn't able to go ahead last year because that was at the start of the pandemic, but he did very kindly agree to give up his time and talk to us again this year. He's the European group head for environmental safety and health. He has a huge wealth of experience leading on large and complex investigations in the defence role. He's also accredited as the lead accident investigator. You know, he's been very generous with his time. So we've got Rob for around about an hour today, roughly a 45-50-minute presentation, and there will be an opportunity for you to ask questions throughout. So if you do have questions, do pop them in the chat bar and we will monitor that. And Rob, with that, I will hand over to you.
Okay, thank you very much. I'll just share the screen. Hopefully everyone can see the presentation title page. Right, well, the first thing I'll say is how disappointed I am. This is not happening in person because, as I explained to the committee, as some of you who've seen me speak before will know, I am an Essex boy. I grew up in Chelmsford, went to school in Chelmsford, and did most of my what were then called articles, now called a training contract, in an Essex firm before I then moved to London, and then in the late 90s moved to Manchester, which is where I now am sitting back in the office. You might be interested to hear. I'll come on to that and home working in a little while. Again, if you've seen one of my presentations with the IOSH branch, it is, as I often describe it, as a bit of a smorgasbord of different topics. Sometimes they're driven by my own or my team's interests. Sometimes they're driven by client interests. So I've taken sort of 5 areas, which you will see if I put this forward. All right, there we go. Sorry about that. So I've selected 5 areas. A couple of general ones, a couple of probably obvious pertinent ones, and something that's a little bit different, but for reasons I'll come on to, because it is the first topic, the risk of terrorism. Something I think more organisations than they realise probably have to start giving this some thought. So let's hope there's something for somebody, for everybody within this 5 topics. So about, oh God, 2015, 2016, my team and I began to present actually on the risk of terrorism and how it might or might not fit within health and safety management systems, and so the assessment of risk of certain types of organisations that were involved in events, venues, crowd management companies, promoters, music companies, sporting bodies, etc. One of the main reasons we began to pick up on it was because you couldn't help read the news, as you can see from this long list of terrorist attacks. But as I say, in around 2015, there were a lot. And there were a lot around the sporting events, and we do a lot of work in that industry. And we began to think about the fact that we'd never seen a risk assessment from any client which identified the risk of terrorist attack as part of its sort of suite of assessed risks. And so we began to think and advise clients, certain clients, that they might want to start to think about the risk of terrorism as it related to their undertaking. Because although obviously the likelihood of a terrorist attack is actually very low for any individual organisation, this country has had for many, many years a severe threat level for the risk of terrorism. And although, as the slide suggests, it might be completely unpredictable where an attack might take place, the event of a terrorist attack is and must be foreseeable. And it must be foreseeable because just look at this long list of terrorist attacks, and this is just a selection. Okay, we then began to think, well, if it's foreseeable, doesn't that impact upon what certain organisations' legal duties must be, both in the civil duty perspective and also the sort of health and safety legal, what I might call the criminal perspective? And actually, when we began to talk to some counter-terrorism experts about this, in fact, I borrowed this slide from one of those, it struck us actually from a very simple legal perspective that the increased incidence of terrorist attack must mean that certain organisations very much did have legal duties to protect their people, protect those who might be affected by their undertaking from the risk of terrorist attack. And as you can see from the very simple graph on the right, the more foreseeable the risk of terrorist attack is, the more likely you're going to have a duty and the more onerous that duty is likely to be. And put in the legal concept, some of you who have studied law will know, the duty of care simply requires the duty holder to have a duty they owe to someone else, And so if you are a venue operator, you clearly will have duties to those visiting your venue. If someone who visits your venue suffers injury as a result, then there may well be a breach of that duty. And if what you suffer was foreseeable, then it adds to the ability of basically the law to attach liability to the relevant duty holder if they haven't met their relevant duty. And as I've said, the greater the risk of terrorism, the more foreseeable that risk is, and the more duty holder is likely to have to deal with. Putting the health and safety legal framework perspective, again, if you have a foreseeable risk, then we know it falls within the structure of the general duties under the Health and Safety at Work Act. You know, if that is a risk which might be posed to your employees, then the Section 2 duty is applicable. And if it's a risk to non-employees, to others, but who may be affected by your undertaking, then it's obviously the Section 3. And of course, just to emphasize, it's not the advent of a terrorist attack which creates liability and a breach, but the exposure to risk that you expose employees and non-employees to. And again, just a bit of a reminder of a legal concept. The risks you have to address under health and safety law are real risks, using terminology used by various courts. Real, not fanciful. The more examples of terrorist attack in an industry, in a sector, in an area, the more real it must be, the less fanciful it must be. And this all goes towards our view, and it was this view in 2016, there are far more organisations than they realised that should be addressing that risk. And we've also seen, since 2015, 2016, the law being applied to show that these duties, the civil law and the criminal law, do actually exist. And I'm not going to go into these in any detail, but you might remember the attack in Algeria on the relevant BP facility. The inquest was very high profile. I know counsel who were involved with that inquest. And in fact, that inquest led to some very significant criticism of various parties in relation to security, which has buoyed those bringing civil claims against the alleged duty holders. And in fact, it's also caused a big fallout around the insurance cover. And we've seen similar claims being brought and dealt with for other terrorist attacks, such as the Tunisian beach attack, which you'll probably remember, and more recently, the Westminster Bridge attack. Interesting that Enterprise, the organisation from whom one of the vehicles was hired, are facing a civil claim based upon duties it is said they owed to others as a result of their practices and failure to assess and deal with the risk of terrorism. I would guess that's quite a tough legal case to be brought against Enterprise. It shows you how lawyers who act for claimants are very much looking at this as a ripe area for potential work. And ongoing at the moment, you no doubt, I'm sure, will have read at some point in the last 18 months about the Manchester Arena bombing public inquiry. I'm actively involved in that. Very adversarial public inquiry, frankly. And there are claims subject to standstill agreements at the moment being threatened and brought against numerous parties, including the venue, crowd management company, British Transport Police, a whole range of duty holders where the claims will be you failed to assess the risk and protect those attending the venue from that risk of terrorist attack. So real life examples of legal claims being brought. Now, so what do you do with this? Well, the first thing I'll say is that this is actually simple health and safety practice and simple health and safety law. Organisations just need to assess whether the risk of terrorist attack connected to their business, threatening their business or their people wherever they do their work, is a risk which just needs to be considered as, is it relevant to that business? And if so, it needs to be risk assessed using, I would say, the risk assessment strategies and skills that you will already know and understand. clearly you do the risk assessment, you then identify relevant control measures. And this is where I think organisations have sort of not necessarily felt that they could do very much. And so I've spoken to organisations who say, well, hang on, terrorism, yeah, well, it may well be a risk, but it's a risk which someone else deals with. It's the police, it's MI5, it's MI6. What can we do as a venue operator or as a crowd management company to stop a terrorist attack? If a terrorist wants to attack, they get past the early prevention mechanisms, then there's nothing we can do. I don't think that holds any water anymore, and anyone who will have been watching the Manchester Arena bombing inquiry will probably have seen the questioning and the attitude of the chairman, which supports the fact that that doesn't hold any water, namely that private enterprise and others can't do something to seek to protect concert goers, for example, from terrorist attack. Now, there might not be that much you can do, but it's not ever going to be right that there's nothing one can do. So, for example, vigilance. Vigilance of your people, your staff, yourselves, as to the risk of attack. So, for example, again, I'm taking the Manchester Arena bombing as an example because it's in the public domain and I know a bit about it. The bombing took place in an area of public realm. It didn't take place in the arena. He never tried to get into the arena. It was in an area of public realm where members of the public went to and from the train station, to and from the venue. It was also a through fare, but there were also other employers whose people came and went in that area. But those other employers, there's no evidence that they actually did any risk assessment, even though it doesn't take much working out that a large gathering of the public in a certain area can be a terrorist target. And if one looked at HSE Guidance, that's what they'd said. There was guidance about public spaces, but there just wasn't the thought that it could be a risk to a particular tenant of that area whose people came and went through that public realm every day. So really, it's just I think the starting point that's being missed by many organisations is actually terrorist attack relevant to what I do? And I would say it is more relevant than many organisations think. The control measures might be limited. It might be keeping your people sufficiently educated and vigilant so they know to report suspicions. If you control premises, you may have to look at CCTV. Does it deal with blind spots? Again, a big area picked up at the public inquiry for the Manchester bombing is that actually the bomber hid for an hour out of sight of the CCTV, but the venue didn't really know where its blind spots were, it's alleged. Hostile reconnaissance. You know, how to report hostile reconnaissance wasn't something necessarily policed very well. And so these things may have had, no doubt it will be argued, an inability to prevent the attack had something been spotted, and if spotted, dealt with in an appropriate way. And that dealing with may simply be calling the police. Okay, so normal risk prevention approach is actually all that's needed. What is missing in my experience is just a sheer recognition that the risk of terrorist attack might affect an organisation. And interestingly enough, as a result of certainly one of the mums of one of the deceased being Martin Hett, Fingan Murray, his mother has a campaign, very articulate woman, very dignified, and she's promoting what they're calling the sort of duty to protect, the protect duties, currently out for consultation. It's worthy of many organisations looking at, frankly, because it is showing the likelihood of some legislation or a change in regulation, which will create express legal duties on certain organisations, including owners and operators of public spaces and premises which invite the public onto them, and or others in the sort of involved in events industry. So you might have promoters, you might have crowd management companies. So this duty is going to be falling upon far more organisations than they think, and what that duty might look like, obviously the consultation will reveal. There's 60 odd questions in the consultations. It's pretty in depth. It's actually sat on the Home Office's desk, so to speak, for at least 12 months, and there's actually now a challenge by some of the families in the Manchester Arena to try to get the coroner to make findings in a chapter he's currently writing, using what's called Article 2 human rights powers, to essentially say that the legal framework that exists, which is essentially the Health and Safety Work Act, wasn't sufficient in terms of protecting people from terrorist attack. Now, I actually don't agree with that. I think the Health and Safety Work Act is a fantastic piece of legislation, sets out general duties, as you know, and if used properly, it was sufficient. It just wasn't used because it wasn't considered that the risk of terrorism was something that more organisations should be considering. But it also looks like there will be some obligations created on some duty holders which might require them to look more closely at the physical side of the security, perimeters. You will probably now see greater sophistication of metal detection equipment at the sort of doorways of many more venues, a requirement to have more detailed training around counter-terrorism, to practice response and mock exercises more. And also there's some organisations are likely to be obliged to employ CT experts as part of their undertaking. So, for example, the then owners of the Managed Arena, SMG, have already employed a former counter-terrorism police officer to be their CT expert. One of the criticisms of them, which they've accepted, they didn't risk assess properly. They didn't risk assess properly. A, didn't really appreciate the risk, and they didn't even have someone actually who could properly risk assess the risk of terrorism. So a lot of things coming out of the public inquiries and this consultation. The simple point, have a think as to whether your organisation might be one where the risk of terrorist attack is relevant to what you do and where you do it. You know, sending your employees to different parts of the world, for example, might be something that has to be given some consideration. So very interesting development. Health and safety law, been around a long time, doesn't necessarily develop in new areas that often. This is one, I think, where it is developing. Okay, something a little bit more obvious maybe, home working. I can tell from the conversation I had earlier with the committee, I know it from my own business, there are far more people working from home. We all know this. Hot topic in the press again today, given the the forthcoming relaxations after next Monday. Home working has been something which numerous people on this this call are used to and will have dealt with within their health and safety management arrangements. But actually, I think it has to be looked at differently. The law, we know what it is. We know the relevant duties as on the slides, section 2, section 3, etc. Management regs, so not just 3, management regs, regulation 3. We know that they ask or require of employers to deal with and take all reasonably practical steps to ensure the health, safety and welfare of employees at work. And that's the thing I'll emphasize, the at work. For most of us, it's in an office, in a factory, on a building site. It's obvious where the at work was. Some of us may have done a bit of work at home. Because it was only temporary, once in a while, it tended to be dealt with in a pragmatic manner, which I'll sort of come on to. And so the question I'm posing really is, well, do we now have to do more? The world is changing. At work, we now have to accept surely isn't just in the office and in the factory, it's also in the employee's own home. They might be at home, but they are at work for a lot more of the time. And I queried how much of the home office, for example, has been properly assessed. And I think that's what the development is going to have to be. HSE have been really good because they were pragmatic about the situation. And sort of this time last year, it's, well, everyone's been sent home quickly. We understand that. There's a bigger issue to deal with. Just, you know, essentially, on my interpretation of HSE, just do your best with this sort of DSE and the home risk assessment. It's temporary, but just do what you can, get equipment out where you can. And I thought a rather pragmatic response to it. But it's more, isn't it? It's got to be more than display screen equipment, which obviously we put in the slide here, which we know about. And as I say, employees working at home is no longer really a temporary thing. More of our employees will be permanently at home or semi-permanent, i.e. sometime in the office, sometime at home. And that must be a material change, isn't it? It must be under sort of the management regs and your duties with regards to risk assessment. That must be a material change, which I think needs you to look back at your risk assessments and your control measures to reassess. So what does that mean? Well, HSE, again, they are helping, I think, and guiding us in the right direction. I really like the fact that they are picking up the mental health challenge that working from home is creating for many, many people. And there are recommendations from the HSE, as you can see, about the risk assessment of this new place of work, so to speak. But I would challenge you all to think this in a broader manner, because where you sit, what you look at, is just part of what you're doing when you're at home, when you're working. And very interesting today, Sage today, there's an article in some of the press about how Sage can't agree between themselves whether people should come back to the office or not. One expert in Sage is there saying, carry on working from home indefinitely. Another expert says, you got to balance it actually, because what about the mental health risk? It's a really difficult area. Again, just means to me, one must pay really particular attention to the risk assessment of it. And let me tell you about a case in Australia. We often talk about learning from America, which I tend not to like when it comes to the law, but Australia is a pretty sound common law jurisdiction, right? And a pretty sound, sensible, pragmatic people. But last year, an employer in Australia was found liable in civil law for harm caused to one of its employees who they had required to work at home during the pandemic. That employee tragically was subject to domestic violence and harmed in that domestic violence because she was spending more time at home. The employer was found liable for that, essentially for failing to know what the court said it should have known. It should have known the broader environmental risks of its employees working from home. And it's an interesting area because I suspect employers would have felt that was going beyond what they was required and sort of interfering with privacy of the employee. But no, the Australian courts felt if you're asking people to work at home, you need to know about the broader situational risks, not just the desk, the computer screen. What's the environment at home like? Does that create a risk? Because it's now their workplace. Okay, so I found that a really interesting development, and one I think may be very relevant to the UK, given its similarities with Australian law based upon English law, frankly. I equally felt that the ACAS guidance on this is also worth considering because it's probing actually at helping the employer understand more about the employee's position, the situation. I'm not going to go through it, but it's worth understanding that this guidance exists and probably have a look at it to see whether it can inform you about your risk assessment and control measures and approach to assessing the risk. Conscious of time, I'm going to move on because I think you probably will get, given your background and your qualifications, what you need to do. But it's a point about understanding the risk and seeing it in its broader sense. Okay, third topic is a little bit technical. It's about a case called Maughan and its impact I think it's going to have on probably fatal accident investigations and also their processing through the coronial system. Some of you may have read about this, and sorry if I'm not teaching you something new, but Mr. Maughan, tragically, this was a death in custody. And there are, tragically, numerous deaths in custody every year, and they are always dealt with by inquests. And very interestingly, in this case, the coroner told the jury, because it was a jury inquest hearing, that there wasn't enough evidence for them to reach what's called a short form conclusion. Short form just simply means accidental death, suicide, unlawful killing. And so instead, the coroner invited them to consider a narrative conclusion, which is sort of slightly elongated. It's like a description, paragraph form. Okay, Now, historically, the position had been for certain, well, for all bar maybe 2 short form verdicts, you just had to be, as a jury, or coroner, when it was a coronal decision, sure beyond reasonable doubt. It was a civil standard of proof. But for 2 matters, or 2 verdicts, now conclusions, suicide and unlawful killing, it had to be beyond reasonable doubt. The theory had been because suicide is actually a criminal offence and unlawful killing is essentially murder, manslaughter, again, criminal offences, and therefore you had to have standards of proof consistent in the coronial system that were consistent with the legal system, criminal system. Okay, and in this case, the jury did find suicide as a verdict, and they found it on the balance of probabilities because the coroner allowed them to find on the balance of probabilities. Now, actually, you might be surprised, but it's not that unusual for families to not want verdicts of suicide. In deaths in custody, there's sometimes a suspicion or a belief from a family that something more untoward has occurred. Sometimes families are concerned about the insurance complications if a suicide verdict is returned. So suicide verdicts are not always welcomed by families, and in this case it wasn't welcomed, and it was challenged because the coroner had allowed a suicide conclusion based upon the lower standard of proof, the civil standard of proof on balance of probabilities, rather than the criminal standard. So it was challenged by the family that it should have been beyond reasonable doubt. And actually a change in law was created by this case, and as you can see from the steps of the appeal court, so first appeal to divisional court, then the Court of Appeal to the Supreme Court, and along the way what we've ended up with, although it was really close in the majority, as you can see in the Supreme Court, in that for both suicide, which is relevant in the Maughan case, but also unlawful killing, the juries are now entitled to make findings based upon the civil standard, the balance of probabilities. So that has been a change in the law. Now that frankly has got defence lawyers like me a little bit worried, because the spectre now is that you'll have more unlawful killing verdicts in fatal accident cases, which might lead to more subsequent prosecutions for workplace fatal accidents. And the Chief Coroner has issued some guidance as a result of this, which this is just to help you sort of understand the process that the coroners will go through. I'm not going to dwell on it at all, but I think what my conclusion is, in light of this change in the law, is that inquests where there may be suicide and certainly unlawful killing verdicts, which will now be easier to find, will be far more hotly contested. I think you'll find insurance lawyers lawyering up to be more actively involved in coronial cases. I think many inquests will take longer, and frankly, anyone who's been doing inquests the last 15 years will have seen an explosion in the amount of resource going into inquests and the length of some of them, but I think they will get longer. I think you'll see more defensive strategies by employers' lawyers not wanting to have an unlawful killing verdict returned. Because unlawful killing allows the corporate manslaughter and manslaughter cases to be more vigorously considered than they have been before. So quite a significant development, frankly, for sort of the defence lawyers in health and safety law. So that's that development. Slightly loath to go too far into HSE's enforcement trends. I'm not an HSE inspector, and of course others on the committee are, but I do always look at the sort of annual reports and just sort of ask myself the question: can I see any trends that might help me and my clients understand what they need to focus on? I think it's worth just looking at them. So here's a sort of a bit of a summary in sort of enforcement statistics, so to speak. And you can see the last 2 periods reported. There's been pretty much a 15% drop in cases prosecuted. Conviction rate's gone up, actually. The HSE tend to choose the right cases to bring. They tend to be very sensible about what to charge, what not to charge. Defence lawyers tend to be sensible about what they can and can't defend. And of course, there's a reverse burden of proof on the defence in any case. So it's actually pretty damn hard to fight and succeed in defending a properly chosen, sensibly brought HSE prosecution, right? So, and that's about as complimentary as I'll be to the HSE. Enforcement notices have gone down 20% or so. Fine levels in these 2 periods have gone down nearly 30% or so. Average fine gone down. We haven't seen average fine go down ever in my career. Is something happening? That was an initial thought. Of course something's happened. COVID's happened, okay? I don't think one needs to read too far into these statistics. I don't think, Adam might tell me otherwise, I don't think HSE is less likely to prosecute health and safety offences this year compared to previous years. I don't think there'll be any less improvement notices. I just think last year was unique. It set a set of challenges to us all, including the regulators, which refocused minds and priorities. What you might see is that this year there'll be even more cases, because we've certainly had cases postponed from trial last year, or postponed from charging decisions last year. There's a flood of them coming this year. So actually this year is going to be pretty busy. But the HSE, I think, as far as I can see, are still focusing on bringing the right cases. Certainly in charging decisions I've seen in the first quarter of this year, they're sensible. I haven't seen any personally poor decisions being brought or prosecutions being brought for the sake of it. There are rules, or there are the Crown Code for prosecutors is being followed. So I think that's really good to see. I actually also think the fines, last year's stats are a bit misleading. Okay, it's because of the number of cases which were actually dealt with in the period was much less. So, for example, in the first quarter of this year, we've seen, I was involved in the case, the prosecution of National Grid Gas, £4 million prosecution, when actually there was no one injured, no one harmed, and in fact no incident, but a significant fine. Still slightly outside of H&S, but we've also seen very recently, of course, the Tesco's prosecution for unsafe food, £7.5 million, and again, actually no one harmed. So the courts haven't forgotten how to fine hard. They haven't forgot how to fine big companies hard. I just think last year was a sort of a one-off. That said, the HSE is still forever helpful in telling us where their focus, where the priority sectors are. And I think any of your organisation's clients who are in the sort of, and these are pretty much the same or focus areas that we've seen for many years. You know, if you're in one of these, you know, you've got to be on your game, particularly as the COVID, I think, situation recedes, gets under control, and the HSE can get back to their day jobs. They have updated the business plan, which again I think is also very helpful steer. I've just pick out selections here. You know, Grenfell still running, but there's learning coming out of it. Part of that, to an extent, is the establishment of the building safety regulator, which I think is a very sensible, actually long needed issue. There's still occupational health focus areas, metal fabrication, woodworking, and we've got some specific proactive areas, I think, around that, as I've listed. Something that interests me significantly is the fourth bullet point, cybersecurity. What on earth has that got to do with health and safety? Well, anyone who read some of the news yesterday in America about the unintentional hacking, well, intentional hacking with the unintended consequences that were safety consequences in the US around significant pipelines. And actually, it is a major worry. We've got some national infrastructure assets in the UK which are very technically sophisticated with IT, software, etc., where you could, in theory, create a major incident by sort of modern hacking espionage. So that is an area which HSE are beginning to focus on, get on top of. And equally, a little bit like that terrorism point from earlier on about how no one risk assessed terrorism as a risk to them within the last 5 years, really, but now they really have to. I think cyber attack is also a safety issue for some organisations and will become a safety issue for more organisations in the future. So that's why we'll focus on those. I also, picking up a theme from earlier, I think it's great the HSE find a place for mental health in its sort of strategy. Actually, I have seen HSE investigate stress claims and mental health issues for some clients in the past. It's a difficult area because of the interplay between work and non-work stressors. It's difficult to extract what is work related and what isn't. But I think it's good to see the HSE are saying that they may investigate, because actually I think employers need to up their game. I mean, many are because of what's happened in the last year, but I think we all need to work a little bit harder to sort of deal with what I think there is growing evidence of the problem. If it's caused in any way by work, it's a health and safety risk. We need to assess it, we need to manage it, fraud and control measures, etc. Right, so the last area I've chosen 3 cases, basically. Just to pick out some principles and some developments. Okay, so the first case is Ahmad. Went to the Court of Appeal back end of the year. We don't get that many cases in the Court of Appeal from a health and safety practice area. So when we do, we sort of make sure we sort of review them. Quite a sad story in some respects, because basically some very, very shoddy attitudes displayed in this case. You can see from the slide some major construction works on a sort of a Victorian building. No survey, no risk assessment, you know, shoddy, as I say. And I think the council had to intervene under their powers to, you know, unsafe buildings, to stop the work. Okay, I've got to say, the lawyers assisting Mr. Ahmad, I think, brought some really poor arguments. But he was charged himself under the CDM regs and the general duties. I'm quite interested that the CDM reg charge was the first charge. It's normally the other way around, normal general duties first, and then the specific reg. But here, it's reg first. I sometimes do wish that it's one or the other, and the agency have been much better at not loading the charge sheet, so to speak. I sometimes wonder what the point is of citing a whole load of regulations and a general duty, given how broad the general duty obligations are. But anyway, it's pretty simple for the prosecution. Mr. Ahmad controlled the site. He was the employer of workers at the site. They were incompetent. They were actually being exploited, poor conditions, poor pay, etc., etc. And there was evidence, documentary, which showed Mr. Ahmad was the person for whom the work was being carried out and was controlling it. But interestingly enough, I think probably being too clever, the defence was all around the fact that he wasn't the employer and that these workers were independent contractors. So actually, the case focused on what is an employer under the Health and Safety at Work Act, because you might know it's not actually defined. But we have tended just to use interpretations from employment law situations. We hadn't seen one of these cases for a while, so that's why I choose it and why I think it's really interesting. And the key part of the defence in the appeal was that one of the workers had tried to bribe someone. That wasn't allowed to be brought out in the trial. The judge stopped that, and that therefore had an unfair impact upon the Mr. Ahmed's credibility with the jury. Again, not a good argument. Court of Appeal threw it out. But they did sort of go back to basics and say, look, let's look at who the employer is, who is in control of the site. And what they said is, yeah, trial judge is absolutely right. You know, an independent contractor can still be essentially an employee, or an employer can still employ independent contractors within the definition and meaning of employer for the Health and Safety at Work Act. And what you look at is, where's the control? Is the person telling them what to do, how to do it, when to do it? Are they obliged to do the work. And all the circumstances led to the fact here that, yes, he was in control. Yes, he was the employer. So it's a reminder, really, this case, that the concept of what is an employer is very widely interpreted. And frankly, it's going to be interpreted in favour of the safety argument, not the employer, not the defendant's position. Okay, so the next case I just wanted to pick up is it's another construction-related case, Connor's Building. Thinking construction in broader sense, involved joinery and a piece of equipment. Anyone who's been involved in the defence side, or in fact the prosecution side, will know that there are numerous cases happening all the time, unfortunately, involving equipment which cut stuff, whatever it cut. Here, it was a timber. The guard wasn't used by the employee. It didn't follow, it was argued, certain rules. But he suffered a really bad injury, frankly, from a piece of kit which should have been easy to control. And simple prosecution, section 2. Here, the defence, again, some strange approach. So, pretty simple prosecution. Prosecution felt no risk assessment. You don't do your risk assessment properly. Got no control measures. They failed to deal with a particular risk. That led to the actual accident occurring. And don't blame the employee for not standing where he's supposed to stand if you don't train and supervise adequately. Now, what I will say is these are absolutely classic causal factors in virtually, I would say, 70 to 80% of the accidents I've investigated and been asked to look at, defend, or plead to. Risk assessment not good enough, training not good enough, supervision non-existent. It is amazing how often those factors are causal, or at least found in the case. Now, actually here, the defence was not so much about what was the causal factors. They just said, this prosecution is just unfair. It's disproportionate, culpability was low, and the consequences of prosecution to the company and others were too great to bother about bringing the prosecution. So the company might essentially lose major customers, Scottish Power being the one cited, they go bust, and a load of people would lose their jobs. So what's the point of bringing a prosecution? Now, I'm surprised those arguments were brought. More than enough cases over time, and some very senior judges, I think Lord Hoffman was one, made the point that, you know what, sometimes it might be right to put a business out of business if they're so bad at health and safety, because we've got to protect people. That's our main priority. So a little bit surprised about how this case came about. I'm also surprised, I think they probably got their procedure wrong, because they should have started much earlier, not get as far into the trial process as they did. Anyway, they lost. You can see £20,000 fine, but they appealed it because they said it was tantamount, allowing it to continue was tantamount to an abusive process. And actually, the HSE hadn't followed their own enforcement policy. That was the main original ground. So failed to adequately consider the consequences of prosecution, i.e. you could make the business go bust. It had been argued that the conviction was oppressive. They said that was wrong. They talk about something called Wednesbury unreasonableness. Well, you might have heard of something called judicial review. Emanations of the state, they get their decisions wrong. For example, it's so unreasonable that a normal state body wouldn't have made that decision. That's Wednesbury unreasonableness. Then it can be a ground for overturning the decision. Now, they didn't bring judicial review proceedings, which is why I think they got the process wrong. They tried to argue it as part of the appeal of the conviction. And they also said, well, the judge is all wrong, because the judge kept saying, these are matters of mitigation when I'm dealing with what you should be fined, not defence, which actually, looking at it from my perspective, that's exactly what I would have said. Court of Appeal, I think, dismissed it really dismissively, actually, and they didn't find in favour in anything. So the message was basically HSE are entitled to bring prosecutions if it's in the public interest to do so. Just because you don't like it or people might lose jobs, that isn't necessarily meaning it's going to be disproportionately. The fact that they could have done other things as well, like an improvement notice, doesn't mean you can't do both. And certainly coming into the court saying, well, you're only just culpable, That's no defence because you're still culpable. So I think it was dismissed absolutely out of hand. But it's a testimony also to the fact that HSE do go through a rigorous process when they choose what cases to bring. Last case I just want to bring up, you might have read about this one as well because it is quite high profile. Drayton Manor Park case. It's a tragic case. A young girl on a school trip falls out of the raft on a certain ride. Actually, where she falls out, she's still able to sort of wade through, climb onto a conveyor belt, but she then falls again into more deep water and tragically drowns. Inquest finds the death to be accidental, but I'll say now that doesn't mean there's been no breach of the law. They're two different processes. And a prosecution was brought, understandably, under Section 3. And the case was essentially made out, essentially undefended, frankly. And again, you'll see, look, inadequate training, risk assessment not suitable and sufficient, those common factors in prosecutions, inadequate control measures. So things here, that's why case was found, why the prosecution should have been brought, and actually why it was accepted. It's more of a sentencing point that I flagged this one for you, because Drayton Manor Park was bust. It's already bust, okay? But they still proceeded. The HSE will do that. Just because an organisation has no money left, particularly if it's liquidated itself after the incident, doesn't mean the prosecution won't proceed. And this is part of the point. Sometimes it's in the public interest to still prosecute, to still send the message. Here, although the organisation didn't have any money, they looked at the case at the time of the sentence. The turnover had been 24 million. It was a medium company. At high culpability and a harm category of 1, that was the range. So they ranged 600 to 2.5 million with a starting point of 950,000. And again, despite the fact that it was never going to be paid, they still fined £1 million. So what's the point of all this? Well, there were still lessons to learn from that case that needed to be advertised publicly. Lack of risk assessment, lack of training, lack of staff. These are things that people shouldn't forget about. And so the court and the HSE, quite rightly, still went through the process and still set a high fine. Even though it was not going to be paid, there's a deterrent effect to bringing these prosecutions. And so, as you can see, it's just a reminder that the HSE see a public interest in pursuing appropriate investigations, even when there are no funds to pay. And actually, that's in society's interest. So those are the cases. Whole load of things there. I've got a little bit longer than I was anticipating, but there's still some time for some questions if there are any.
That's great. Thanks very much, Rob. That was incredibly interesting, and I've got some thoughts on some of the things you said there as well. So before I do summarise, Mark, have we got any questions that have come in on the chat? And while Mark is asking those questions, if any of the others do have questions you would like to raise, do type them in the box, or when there's the opportunity to come off mute, and you can ask them to Rob yourself directly as well.
So there's no particular questions. However, there was a statement around the working from home and civil liability. So I'll read that out anyway. So the statement is, surely the duty of care falls under the security services and of the police for what is protection of the public. Though commendable to use private contractors to train for additional cover, but if with the initial provision there was a shortfall, then notification should be made available. The security services potentially would have prior knowledge. If that is ignored, then would be a liable case for compensation. Again, that was a statement that I didn't really pick a question out from that.
Well, but if I could just comment, again, I'm still involved with the Manchester Arena bombing, public inquiry. The one thing I am certain the chair will comment upon was, and in my view anyway, about how for safety law should have applied. There were numerous organisations that each had a duty which would have overlapped, and had there been greater coordination, there might have been a greater chance of avoiding what happened. The problem is, and I had this put to me yesterday by a lawyer who's helping us, an association, respond to the Protect Duty consultation, is that there's been more recently a trend where the police and the state, with its limited resource, has sort of stopped in what, as a set a limit to what it wants to do, what it feels it can do with regards to the public realm area, and is trying to get and pass obligation to private enterprise. Private enterprise stands there and thinks, well, hang on, we don't police. The police and the state are supposed to stop terrorism. Actually, the law means that they both have a role, different roles, but they both have a role. So if you're a venue, you have a role to identify, are you at risk from a terrorist attack? If you are, what can you reasonably practically do to limit that risk, which might be looking at where your security perimeter is. It might be looking at what your hostile reconnaissance program is, what your reporting program is, and also how much intelligence or otherwise are you getting from the state to help you assess the risk. And it's very, very clear there wasn't a huge amount of coordination in respect to the Manchester arena. Now, interesting, if you speak to someone who's involved in the creation of festivals or one-off large public events, there's a hell of a lot more coordination through the safety advisory groups. They don't operate in the same way for numerous events happening at big venues. So there's an interesting difference of approach in almost the same industry. And there should be some learning from one to the other.
So it's over to you. There's no more questions in the chat box.
Okay, we just have one more comment from Stephen. Hi. On terrorism, one role of employers must be to plan responses if an attack occurs to protect clients. Yeah, I guess that could be off of the back of the media interest surrounding the police response there.
Yeah,
Rob, if you're involved in that, you're know more.
And there's more than that, actually. One of the chapters that has been heard recently is about not only the emergency services response, because there were, you may have read that the fire service were kept out for a period of time, probably defensive management and also lack of proper comms coming from the ground. But also the emergency provision, the first aid provision, is being challenged very much as to what was in existence by the venue. There are terrible scenes of people being carried out on makeshift stretchers, for example. There was evidence that the arena had not replaced some of its more expensive stretchers and the like. So, yeah, the emergency response has definitely been looked at, but not just from the state's perspective, also what role other duty holders will have had in terms of emergency response, particularly the venues. So I think that's that'll be interesting to see how the chairman makes recommendations around that area.
And Rob, from a cost perspective, the police, the ambulance, the fire, they have a response duty. They also have a presence at these events. So who typically pays for that? Is it a mixture of public and the event management company, or is it?
Well, that is one of the problems in the police have in more recent times been trying to get some of what had been their historic role funded by private enterprise. And so there are 3 or 4 cases, so there's a case, Leeds Festival against West Yorkshire Police, there's a case involving Ipswich Town, and there's another case where basically the police claimed a load of money. But there's legislation around special police services, and there's been an argument over whether dealing with policing around events or special police services should be paid by the event organizer and not by the state. It's one of the reasons why, for example, you see less police around football grounds, around the queues. They don't see it as part of their statutory function. And if you want it, you've got to pay for it if you're the football ground, even though it's in an area that the football ground don't control. And this is what the problem about public realm is. There's been a misunderstanding and different perspectives as to who should be responsible, hence the duty to protect and hence the inquiry. I think we'll start to set out a little bit more clearly who's responsible for what and how those duties overlap. But you can't ignore the tragic evidence of the British Transport Police officers who unfortunately just were not doing their job. A lot of evidence around the 2-hour lunch break, the fact that their own system said that they should have been patrolling the relevant area where the bomb was detonated at the time of detonation, and they weren't. The 4 officers, who were all very junior, not enough of them, not enough supervision, no senior person there, they were stood together at the bottom of the relevant stairs that the bomber had gone up an hour earlier. He actually passed them, but they actually weren't following even the limited process that BTP had actually set out. So tragically, a lot of learning for a lot of organisations, including the policing services.
Yeah, okay. Well, I think I'm thinking back to some of the comments you made there about terrorism, about cybersecurity. If anybody is interested, there is actually a national risk register which the government produced, and that highlights the key risks to the UK, both malicious and non-malicious, which covers terrorism, cybersecurity, and flooding and all the works, which is worth a read and will be relevant to some of the industries that people do work in. I very much enjoyed the positive comments coming to HSE. That's lovely to hear some from the defence praising us so much. So thank you for that. I'll pass that on to Matthew as well. The comments you made about the fines, it's worth differentiating between the fee, which is cost recovery for the work that HSE have done, and the fines, which are only issued by a court. So it isn't HSE who decides that. They're always imposed by judges. And in terms of them being less likely, you are right, there are a lot of cases held up at the moment in the court system, and hopefully we'll be able to get through the backlog as and when. Notices, we do try to be proportionate. We're never in the business of trying to close down businesses. We just want to make sure that when they operate, they are operating safely. In terms of upcoming priorities, if any of you work in fabricated metal, then HSE will be looking at metalworking fluids and welding fume from May to September. And the mental health side of things. I know a few of our inspectors have started to get training in the mental health side of investigations now, but health in general, both mental and occupational, are difficult investigations because of what goes on inside and outside of work. If you've got somebody who's suffered a serious physical injury, it's much easier to pinpoint where that happened than maybe some sort of dermatitis or manual handling sort of injury. That's it from me. I'm going to hand over to Kieran and Lawrence, but thank you very much, Rob, for talking to us today.
Thank you.
Over to you, Kieran, when you're ready.
Good afternoon, everybody. I'm Kieran Delaney. I'm one of your Vice President's team, and I'm delighted to see one of my favourite colleagues, Mark James, on the call. Just to embarrass the hell out of Mark, he is one of the most competent members of council that I know. He is a person who discharges his duties in a professional manner, and I'm proud to call him not just a colleague but a friend. I also note that we have former IOSH president on the call, Ray Hurst, and just to welcome Ray. And I'd like to just invite Lawrence Webb, who's also a vice presidential colleague, to say a few words. Lawrence, over to you, my friend.
Brilliant, thanks, Kieran. Hi, everyone. I just wanted to take 60 seconds to briefly introduce myself. I'm really pleased, actually, to see how many people I actually do know on this call, which is nice. But a little bit like Kieran, we go around as teams, but also individually, to make sure that everybody at the different branches know who we are and what we do. So my day job is as the Group Safety, Health and Environment Strategy Director for Costain. I've been working with them on and off for sort of over 20 years, but throughout that entire time, I've been a volunteer for IOSH, and I've done a whole range of things, from sitting on council to advising on blueprint competencies, training materials. I sit on the IOSH construction group. Also a couple of focus groups as well at the moment, but I just really wanted to allow you to put a face to a name, if you like, and just let you know that what Kieran's about to talk about and what we're doing as a presidential team is absolutely there for the benefit of the membership, and to make sure that IOSH is giving back exactly what's needed by the likes of yourselves. So I won't say any more than that, but just to say, great to see so many of you here today, and certainly enjoyed the presentation. Thanks, Rob. Over to you, Kieran, and I'll chip in if you want me to.
Lawrence.
Thanks very much, Lawrence. I'm having a few technical difficulties because for some reason I can't screen share, but I'll keep going. So, as I said earlier, I'm Kieran Delaney, and over the next few minutes, I'm going to give you a quick overview of IOSH, looking at who we are, what we do, our vision, our strategy, and our priority areas. I look at how IOSH membership can help you and how you can ensure that you get the best out of belonging to IOSH, along with how we are future-proofing the profession and continuing to provide high-quality training products. And finally, I'll examine the latest developments with the global working model, including how we are collaborating with like-minded organizations around the world, and I'll address the roles we've had in addressing the COVID-19 pandemic. Everything we do is to support our vision, which is a safe and healthy world of work. We know that realizing this, moving towards it, brings benefits for people, businesses and communities, societies and economies. The framework for achieving this vision, our Work 2022 strategy, was launched globally in April 2017 in Qatar. We chose the Middle East for this launch because it's home to some of our most active, successful and fast-growing network of members. Most of this growth is driven there, of course, by the sector where the greatest number of our members work, construction. Work 2022 is designed to align with the changing work patterns and workplaces, structured around an approach where we collaborate to influence and enhance our profession in ways that will achieve a safer, healthier world of work. We work worldwide with key collaborative partners and strive to improve work safety and health in ways that meet both local and regional needs most effectively. To focus our work effectively on key concerns within the broad span of safety, health and well-being, IOSH has 6 priorities: musculoskeletal disorders, well-being and mental health, occupational cancer, sustainability and human capital, and rehabilitation and non-health related activities. Now, if you just give me 1 second, folks, I think I have got that facility. So just give me 2 seconds and I might be able to.
It's me, Kieran. It's teamwork, mate. It's all about us doing it together. So I've shared my screen, so you carry on and I'll move along as you want me to. That's
fantastic. Cheers, my friend. So if we go to slide 4, we're talking about our offers to the membership, which is growing, meaning that our members are receiving a significant return on their or their employer's investment. So to go clockwise from top left, IOSH's stamp of excellence is being a chartered member of IOSH, and we're the only chartered body in this sector striving to achieve the highest professional standards. Our competency framework helps you to identify competencies you require for your role and plug the gaps, and I'll speak more about this shortly. IOSH mentoring, providing you with access to a network of members to help guide you, or as the mentor, giving you the opportunity to support others and give something back. Networking and events. This has moved online since the beginning of COVID-19, but IOSH membership opens a host of opportunities to make connections and hear about good practice. And if you think about last night, you had a fantastic webinar in conjunction with both offshore and one of the Scottish branches, where Leslie shared a very, very moving story about the passing of her brother due to an accident. Our No Time to Lose campaign, you can access resources on how to manage occupational cancer risks in your workplace. IOSH Extras, there's lots of exclusive discounts and benefits available to you. In the IOSH magazine, you can get the latest news, analysis and information relating to our profession. Our Independent Benevolent Fund, which can provide support to members going through difficult times. And I would appeal to you to avail of that if you need it, or to guide colleagues that you may be aware of need that extra bit of help. It is totally and utterly confidential. I cannot stress that enough. No member will know who you are. The only people who will know who you are IOSH staff, and they just anonymize the information and it's passed to the Benevolent Fund trustees for their decision. The Future Leaders community, you can join our network of future leaders and develop and learn together. That is something that Mark James is absolutely passionate about. And our Career Hub, where you can access information about the latest jobs and tips of how to enhance your jobs prospects. These are just some of the benefits of being an IOSH member. Next slide, please, Lawrence. IOSH recognises that IOSH professionals must be able to respond to the needs of businesses. That is why, through IOSH membership, we supply future leaders of both the profession and organisations to the market. We have various routes into membership, which we empower through a combination of our blueprint competency framework and supports development, and is assured through our CPD programme. As a vocational profession, it is important that we understand the future needs of organisations to ensure that we are preparing individuals to be impactful for their employers and successful personally. Therefore, we work closely with business leaders to ensure that we understand their future opportunities and challenges to ensure that we remain relevant and valued. As OSH professionals develop, they gain the combination of skills, knowledge and behaviours to be both competent and highly impactful in their roles, benefiting both the individuals and their organisations. This combination of personal growth and delivery allows individuals to progress through our membership grades and ultimately to have their competence recognised as a chartered health and safety practitioner. So more about our competency framework. This framework sets the standard of skills, knowledge and behaviours of people working in OSH to manage risk and drive change in today's increasingly complex workplace. The framework has 69 competencies across 12 areas divided into 3 categories. Technical competence covers health and safety law, risk and incident management, and new technical understanding on subjects such as ethical practice, ethical understanding, human capital and community impact. Core competence covers good decision making in the workplace, and behavioural competency includes communication, working with stakeholders and personal performance. This framework recognises the continuing need for technical competencies, but expands the range of skills, knowledge and behaviours to reflect the growing influence of health and safety in organisations. It's arguably the most comprehensive competency framework available for the occupational health and safety sector. Now, the thing that you've been most waiting for, the membership grade review. Many of you will already be aware of this, but just to recap, IOSH conducted a review of our membership grades in consultation with members and various stakeholders as part of IOSH's Work 2022 strategy. The OSH profession has changed hugely over the last decade or so, and we need to ensure that IOSH's membership grades are current and relevant so that they continue to support career progression and meet the needs of employers. Survey feedback indicated that members recognise change is needed in IOSH's grades to keep them current and relevant, and therefore acknowledge the need for grades review. At our October AGM, the membership voted in favour of special resolution seeking changes to our bylaws as a result of membership grades review. 84.1% were in favour. IOSH is now waiting to hear back from the Privy Council. Once we have that response back from Privy Council, we will confirm launch timings and provide an update on other key developments, including the ethics certificate, Blueprint 2.0, the new CPD scheme, and the associated assessment and transition processes. These are all progressive developments which will significantly enhance the way we support members through their careers. And if you as an individual need more information, please email grades@iosh.com with your query, and the team will revert back to you with an answer as fast as they can. IOSH is not just only a membership body, we're a leader when it comes to development, safety and health training courses. We have a suite of courses which are divided into 4 levels. They are executive, management, core and professional. These 4 levels, when dovetailed with the competencies, are a very powerful tool for OSH professionals to leverage when considering CPD opportunities and how those opportunities are aligned and desired by businesses. A tried, tested and trusted approach is to provide a model which works from either top to bottom or vice versa. We would always encourage adoption of the executive program first, as this is one of the key ways OSH professionals, in conjunction with behavioural competencies shown on the previous slide, really start to see themselves as having an impact at operational and strategic level. The management program embeds the basic OSH skills that non-IOSH specific roles require, By adopting these courses, you will see firsthand how value is brought into the business as well as attaining personal CPD points. Our core program really supports frontline workers and the professional pillar, where our level 3 safety and health for business certificate resides. And this has been specifically designed to be practical and business centric, with lots of tools and tips and advice on how to thrive in a business environment. In 2020, the world as we know it changed, and IOSH responded and made its level 3 qualification available online. Our qualification is the ideal next step for anyone wanting to become eligible for associate or technical IOSH membership. Having it available online means it can be accessed by anyone no matter where in the world they are. This course consists of a one-to-one learning hours made of up to 10 days worth of e-learning sessions and self-study. You can complete the course at your own pace within a maximum time limit of 24 months. You will have access to a virtual tutor who can guide you with any questions you may have along the way. The course is assessment based, so there will be no complex sit-down exams. Assessment can be applied to your workplace or a case study of your choosing. Why wouldn't you choose this route? More details of our course offerings are available on the training and skills section of the IOSH website. All of this is contributing to IOSH delivering its Work 2022 strategy. To fully deliver on it and realize our mission, we must collaborate to influence a global scale to ensure that occupational health and safety standards are as good as possible the world over. While COVID-19 has put a stop to international travel, IOSH has continued to operate globally. In 2020, we signed 4 memorandums of understanding with the World Trade and Tourism Council, IOSH in South Africa, the Chartered Institute of Personnel Management in Nigeria, and the International Social Security Association. Our close links with these organizations will help us continue to influence safety and health standards around the world. In the case of ISSA, the partnership is already paying off, as in October 2020, we launched the Vision Zero training package developed in collaboration with them. The aim of this package is very, very simple. It's to make workplaces safer and healthier. So what about other global work? We have been working closely with the World Health Organization to share information and guidance on managing the risks of COVID-19 in workplaces. In West Africa, November last year, we launched our IOSH West Africa division to provide a natural home for OSH professionals in Ghana, Nigeria, and other West African countries. And following an application in August last year, IOSH was granted an accredited organisation status to the Commonwealth on the 26th of November 2020. And then earlier this year, on March 8th, IOSH joined the UN Global Compact as a non-business participant. This is a significant moment in the world of work. It's been a year of tragedy and challenge. Past year, pandemic has been seen globally as basically being one of upheaval and really experiencing peacetime. And it continues to present problems in our everyday lives and employment. The OSH profession has been instrumental in helping frontline workers and all other employees deal with the hazards presented by COVID-19. And IOSH has responded to its members' needs and insights sought by business in many sectors and countries. COVID has changed the way that we work and the way we live, and IOSH and our members have demonstrated how to adapt and improve. The work is continuing to keep pace with the challenges we all face. The pandemic has provided organisations with an opportunity to review what we do and seek ways of improving and innovating how to survive. They have a real chance to build back better. Global safety professionals certainly providing COVID-19, and for considerable time before that have been challenged by businesses to provide levels of assurance not typically left to OSH professionals. Part of this need for assurance is evidence that the role on the contribution that OSH professionals are making is not only on the increase, but sought after by business and industry. And if you think about it, media, especially those that have been associated with the health and safety, blunt stories that don't hold any credence. Amazing how fast they reached out to IOSH and OSH professionals to seek reassurance. The opportunity that presents itself to global AOSH professionals is that this assurance sits in a sweet spot where few professions get a chance to regularly operate. If equipped with the right if equipped with the right knowledge, skills and understanding, we as AOSH professionals will be key to unlocking not only the potential within ourselves and our teams, but we will make tangible connections to senior business leaders. Furthermore, business leaders will then feel empowered to approach investors and governments to further support the global vision of AOSH professionals. We can achieve these changes together, and IOSH will continue to support a world of work in these efforts. Thank you so much for your time this afternoon.
That's great. Thanks, Kieran. If I can just add something on the end here, I'm delivering this same presentation at 2 branch meetings tomorrow and Thursday, and I just added in just one additional reminder to people that there is a lot of different focus groups, committees that are all going on in the background in the name of the membership, and obviously Kieran and Mark and others on this call today will be familiar with these. So just as a few examples, we have a focus group subgroup, which is a fantastic title, just making sure that the board of trustees are actually being held to account for the great work that they do. We've also got one that's ongoing as a bit of a focus on mental health, to make sure that as time moves forward that IOSH, the organisation, is again giving back to members what's needed from that perspective, and you'll see some things come out of these groups in the future. And please don't forget that there's also some external groups that aren't there for members of council, but they're there for all of you. So I mentioned earlier the IOSH construction group. There's also more recently the Armed Forces and Veterans group as well, which is something that our president Jimmy Quinn was absolutely insistent on getting set up, and that is going great guns. We've already got close to 400 members now, I think, of that particular group, for those who are about to leave or transitioning from the armed forces, to make sure that we can do whatever we can to support them in their new careers. So please keep an eye on these, because a lot of them are open exactly to those people on this call today and across all the other branches. So the more you get involved, the more we know we're doing what you need. So hope you don't mind me jumping in there, Kieran. That was one for me that I forgot to warn you about.
No problem. The other thing, and I'm sure that Mark James may like to just support this, is that Jimmy Quinn has organised coffee mornings for members to pop in to. So if you look at Jimmy Quinn's LinkedIn page, there is an invitation there. But I just want to thank the Essex Branch on a personal standpoint, because I have attended a number of your events over the last, 18 months is it now, since COVID started. The quality that you consistently deliver, folks, oh my God, you're absolutely brilliant. And Mark James will tell you that, as mentioned, I don't give praise lightly. I say it as I see it. You are fantastic, and please continue to do what you're doing, because you just really keep on knocking it out of the park. So thank you so much for your time this afternoon.
Thanks, Kieran. Thanks, Lawrence. It's really good. We just had one question on that, and that's from Paul Thornton. Hello, Paul. What level is the IOSH qualification?
Yeah, I've actually just gone back to Paul on that one directly. My apologies. If it's the one I'm thinking of, it's at level 3.
Okay, so level 3 for the IOSH qualification. Okay, Paul, that's answered that. Okay, great. Well, that wraps up today's meeting. Thank you to our presenters. I think Rob, he's a very busy man. He's had to disappear. And I'm sure that, as Lawrence said, that there's some other presentations that they've got coming. Can I just ask the committee, both new and old members, to stay on, and the rest of you, thank you. Don't forget about our next event on the 1st of June, Navigating Success. That link is in the chat if you wanted to register, and also on our LinkedIn pages. And apart from that, we shall see you all again very soon. Thank you.
Thanks very much, everyone. Good to see you.
Cheers, Lawrence. Kieran.
Thanks, Brendan. I know you've got to disappear quite sharply.
Yeah, I can stay on